First of all, these speakers will follow Julian without introduction. There's former Justice of the High Court, Ian Callinan, Dr. Gary Johns, a former minister in the Keating government, Major General Jim Molan, former Solicitor General David Bennett, Brigadier Jim Wallace, Alan Anderson, Ben Jellis, and Amanda Fairweather. I'd now like to introduce Julian.
Thank you very much, Tom. General Cosgrove, ladies and gentlemen, thank you very much for coming here today to the launch of Don't Leave Us with the Bill, the case against an Australian Bill of Rights. As Tom alluded, we were greatly honoured when General Cosgrove agreed to launch this book. I can't think of too many Australians who've done as much in a practical sense to promote and preserve human rights in our region as General Cosgrove, and I'd like to thank him on behalf of the Centre again. It's been wonderful. Can I also join Tom in thanking all of the authors who gave of their time, their experience and their knowledge to put together this book. It's really been very, very rewarding to edit with Ryan Hadrick. And can I also thank my co-editor Ryan Hadrick for his efforts in this regard. His particular chapter in this book on the dubious constitutional validity of the Statutory Bill of Rights bears particular study. As Tom said, this is the first book that's been published providing a comprehensive case against an Australian Bill of Rights. And one of the things I think that marks this book out compared to other books on the pro side is the experience of its contributors, but not just the experience of the contributors, the fact that there are a range of new voices from a new generation providing different analysis to some of the problems that a Bill of Rights creates. All of us believe in human rights, but this debate is about whether the Bill of Rights, that single mechanism, makes an improvement in our system of government and makes an improvement in our rights protection mechanisms. Those who want a Bill of Rights have the burden of proving not only that the current system is broken, but that theirs is the best method of achieving rights protection. I just wanted to, as I do in my paper, examine two of their arguments today. One of the first arguments they make is to tell us that nations around the world have adopted bills of rights and Australia's almost the odd man out in not doing so. I think there's two things to say about this particular argument. The first is there are many nations all around the world that don't appreciate democracy and don't love freedom but have bills of rights. And then there are other nations like Canada, like the United Kingdom, like New Zealand that have a Bill of Rights. And although they sound like nations that are very similar to us in culture, indeed their political culture is quite different. We've had a written constitution since 1901. We've had a popularly elected upper house since 1901. We have a range of rights protection mechanisms through our administrative law and through our judicial review that Australian citizens can access. We have compulsory voting. The voice of the minority through minor parties is really taken into account. These make our system demonstrably different from Canada, from New Zealand, from South Africa. Another argument that they make is to say that a Bill of Rights will help solve human rights deficiencies in our nation. Again, I think we need to look at the experience overseas and in the two Australian jurisdictions that have introduced a Bill of Rights. By its mere presence, a Bill of Rights does not change culture. The thing that changes culture, the thing that changes the quality of our public service is the quality of our public servants and the attitude and ethos that they bring to the administration of government. A Bill of Rights did not help the victims of Hurricane Katrina in New Orleans. It didn't stop the school closures in Canberra that occurred with no consultation. It didn't even help the bushfire victims in Victoria who cannot get representation before the Victorian Bushfire Royal Commission. We say that the best way to improve human rights protection is to improve the culture of our public service and to address specific concerns with specific policy and specific legislation. Addressing concerns directly means that you actually deal with a problem directly and you avoid the downsides of a Bill of Rights, the uncertainty and vague language, the politicisation of the judiciary and the creation of a rights culture. The truth is any Bill of Rights has three main shortcomings. Its vague language gives rise to serious uncertainty in the law. As citizens and as governments, we need to know what the law is in order that we can act upon it. It provides a range of unintended consequences, and you'll hear some of those from our authors today. And it undermines our political system as judges are forced to interpret laws not according to the intention given to them by our representatives, but in order to comply with some vague human rights notions. Australians would be foolish to acknowledge that this will not be translated here. Our human rights record is the envy of many other nations. And indeed, I was thinking this morning that this book launch, better than anything else, demonstrates why we don't need a Bill of Rights. Here we are gathered today, exercising our right of freedom of expression, freedom of assembly, freedom of association. Here we are criticising a policy of the elected government of the day, and yet we know that no policeman, no government official is going to come and shut this meeting down. And yet we have these protections without a Bill of Rights. How does that happen? That happens because in Australia we are a rights-protecting country and we are a rights-protecting culture. In a moment you'll hear from some of my co-authors, but let me just conclude making two further points. If you're concerned about having a Bill of Rights in this country, there are two things you can do. The first, and this will be a shameless self-promotion, is to buy our book or to visit our website nobillofrights.com.au. But secondly, and most importantly, we need the voice of people who don't want a Bill of Rights to be heard. And what you can do is you can make a submission to the Brennan Committee. Go online. You don't need to write very much. You just need to tell them that you do not want a Bill of Rights. And this leads me to my final point, and it's a point we've made in the book. If Australia is to rearrange its system of government and bring in a statutory Bill of Rights, then all Australians deserve to have the right to vote on this question at a referendum. Although it doesn't change the Constitution, it so fundamentally alters our system of government that we should have a direct say. If we could have a direct say on something like our national anthem in 1977, then surely we deserve a direct say on an issue as fundamental as this. Thank you.
Ladies and gentlemen, I don't wish to add very much to what I've written, but could I say this at the outset? Bills of Rights politicise courts and judges. If you don't believe that, you will soon see it to be true by reference to the United States. The President of that country is about to nominate a candidate to the Supreme Court. You will see in evidence an intensely political process in the course of that nomination and ultimate confirmation. The politicisation begins there. And you know why it begins there? Because the principal activities of the Supreme Court of the United States involve rights questions. They dominate everything else. That's where the politicisation begins, and it continues. If you read the books, if you read the literature of the insiders relating to the United States Supreme Court, you will see that the intercourse between the judges in relation to these questions is intensely political. Their whole process is really the antithesis of the sort of legal process in which courts generally indulge in this country. I don't want to see that happen here. I think it's undesirable. I agree with Peter Cosgrove that in general judges do lead cloistered lives, and there's a reason for that. It brings with it an important degree of detachment. We are not the right people as judges to decide sociological and political questions. There's also a practical aspect to this matter, and it will also be seen, I might say, in the process of the appointment of the United States Supreme Court judge. And it is that the emphasis will be upon the sociological and, I would say, political inclinations of the candidate. Far too little attention will be paid to the technical expertise and the experience of the candidate. And you will find that many of the appointees to the United States Supreme Court are people who have not had the sort of direct experience that lawyers in this country have, and which they bring into practice and they bring to bear upon their judicial work when they're appointed. It's some 53 years since I saw my first court case, And I must say that my view of the Australian judiciary at all levels is one of detachment, expertise and conscientiousness. Of course, it's not perfect, but the qualities that it does have are a great deal to the definition of the tasks that it has to carry out. And those tasks are neither sociological nor political. I just conclude with one other observation. Those who advocate a Bill of Rights take the high moral ground, the sometimes sotto voce, sometimes quite explicit accusation against the opponents is that they lack compassion. Well, I entirely reject that. The judiciary in this country is compassionate, and I might say the common law, the British common law, the sort of system that we have, is a system of compassion. And it is a totally unfair, ill-founded and ignorant accusation to make that those who are opposed to bills of rights are not compassionate. Thank you.
Thank you, and congratulations to Julian and Ryan for their good works. Now, we thought that we should apply the powers of a Charter of Rights to easily the most difficult social question in Australia, which is the plight of Aboriginal people, to see if it might help. And I have to report that it won't. If, as we've done in this chapter, to concentrate on the notion of rights for Aboriginal people, we must talk about land rights. That's been the signature political event in Aboriginal lives in the last 30 or 40 years. There's a little roll call I'll just read out for you. Remember these. The destruction of Mapoon at Cape York in 1964. The walk-off at Vestey's Wave Hill Cattle Station, the northwest of the Northern Territory. The Yirrkala Arnhem Land fight against Nabelco in 1968. And I had another. Those are the key and signature moments of political struggle. And later, of course, Mabo through the High Court. Through political struggle, it looked as though Aboriginal people were gaining decisive rights and benefits. Nowhere was there a Bill of Rights or a Charter of Rights to be seen. So the Charter is late on the scene. Whether or not it could now benefit those people is doubtful, because I've had a look at those four signature battles that took place in these places, Noonkanbah and Mapoon and Wave Hill and so on. And each of those four, and I can report to you most others, are poor and places that do not provide a life for Aboriginal people. And a better life for Aboriginal people simply does not exist in legal mechanisms. You can open the gate, but to get someone to walk through that gate into a modern world and to learn how the market system works does not come with a ready-made book of rules. So a Bill of Rights, a Charter of Rights, will not assist here. And let me just make one quote and leave you with this from a very decent person who had great hopes for land rights for Aboriginal people. And this is Mr. Justice to his remarks at the granting of lands to the Walbiri people under the Northern Territory Land Rights Act of 1976. Quote, "There will be benefits to the people of a spiritual and psychological nature. Mainly, I think, in the impetus it will give to the movement away from centres of high population and the opportunities to return to a more traditional way of life." End of quote. Now, I think Tui would find that a tad embarrassing, 30 years on, that people who gained their land rights have either sat on the land and become poor, or have left their land and gone to Alice Springs, where the current government will soon take over the Tangentsia Council and restore those lands to the Commonwealth, if you like, and put it in the hands of people who will be able to deliver services to Aboriginal people and hopefully bring them into a modern and healthy world that we exist in. So if we apply the hope of a Bill of Rights to Aboriginal people, those who might most need it, you will find that there is no solution for them. In fact, I think it will delay the day to which they need to enter our world. Thank you.
Ladies and gentlemen, I make my contribution to the case against the Bill of Rights as a recent Australian military practitioner. My study of the law is restricted to those laws that apply to me as a military practitioner, especially the laws of armed conflict. But I've applied those laws during conflict in which the consequences of my actions were extreme. One of those occasions corresponded with the crash of the British Hercules aircraft referred to this morning in the headlines. It's very early days yet and the reports are confusing, but there are now several recent cases of servicemen being killed because of equipment failure that have been linked to the UK Bill of Rights. Reports seem to say that the rights of soldiers have been transgressed because their equipment failed to protect them. It's a powerful, emotive and political argument to link tragic deaths in unpopular wars, the failure of equipment to protect and a Bill of Rights. Who could ever take a stand against the maximum possible protection of servicemen? In my view, the issue is not rights, it's why your soldiers are fighting. Surprisingly, not all military deployments are conducted in order to win, despite the rhetoric. If you're going to take part in a conflict for your main purpose of supporting an ally, quite legitimately, but this involves protecting your soldiers to an infinite degree and bringing every single one of them home, then I suggest that you cut out the middleman and have them all stay at home where it's very safe. I refer to these kind of conflicts as conflicts of choice. If you have the choice, then stay out of the war until you have a perfect military. If you're in a conflict where you actually have to win, then you have less choice and the situation is different. No military in history has ever perfectly prepared for any war, and I wager that no military in the future will ever be perfectly prepared. Wars are won by those who take risks. The battlefield is an inherently dangerous place, and even a military that approaches perfection will take casualties, especially if in order to win, the military must actually take the offensive, that is, get out and find the enemy, hunt them down in order to win. Australian forces will be lucky in the future to continue to conduct military operations where casualties on either side and for civilians are low, as we have since the early 1970s in Vietnam. This is not the general experience of wars across the world at the moment. Current military operations, as I saw firsthand in Iraq, are the kind of operations that most militaries will face for the foreseeable future. Modern conflict is violent in the extreme. That violence occurs amongst a civilian population. The legality of our position is critical. The stakes are huge for all concerned, and the laws of armed conflict, even though only applied by our side, serve us very well indeed and are a manifestation of our morality. Our government has indicated in the recent white paper that they think that not only are such wars amongst the people, as we call them, likely to continue in the immediate future, but that state-on-state wars or conventional wars are more than possible in the longer term. Our government is intent on buying billions of dollars worth of equipment to meet this perceived threat. If we are to believe the intelligence forecasts, it may be critical in the next 30 years that the Australian Defence Force can perform as a world-class military, a military that is not surprised by unforeseen effects of legislation that are either naive or ideologically driven, and that its modern command culture is not compromised. Our society expects its military to wage just war in accordance with the laws of armed conflict, to protect both its soldiers and its citizens and to actually win. It's difficult for us to talk of the effect of a Bill of Rights on the military at the moment because we are talking in the abstract at this early stage. But I fear that the unforeseen will occur as it normally does, and the consoling words of drafters of human rights legislation will turn out to be only words, and their handicraft will impact unfavourably on the Australian Defence Force. The ADF will then be left to pick up the pieces as the naive and the ideologically driven move on to their next project. The ADF must prepare itself primarily for once-in-a-generation substantial conflict, and that conflict must be won, and so too should mooted legislation such as a Bill of Rights. Up until recently, I would have said that interference through a Bill of Rights was ridiculous. It could never happen, because I had faith in our society that normally we do not do the really stupid thing. However, the United Kingdom's Human Rights Act does not instil me with confidence. The major concern for me is that the unintended consequence of the application of a Bill of Rights to the ADF will be to replace an operational command culture that is now based on trust between subordinates and superiors, a reliance on initiative and an acceptance of risk, and will be replaced with a safety-first culture that is based on fear of legal review. It's my concern that the territorial application of a Bill of Rights will not be considered within the public debate, and the government will not give proper or detailed consideration to the operational requirements and challenges of the Australian Defence Force's deployments in various theatres around the globe. We now see this happening in the UK, and I discuss this in some detail in my contribution to the book. All sorts of assurances were given in the UK as they considered how their defence forces might achieve their military objectives, that is, to win, whilst also observing their obligations under the Human Rights Act over the last 11 years. What eventuated was not what the British government thought would apply. It is not what was in the submission to the Judicial Committee of the House of Lords, which stated that the Human Rights Act does not apply to overseas territories of the United Kingdom, and which was seen as a general and well-established principle of statutory interpretation. So it might not only be the ADF that will be surprised by what such an act might mean in the future, but if the UK experience is any guide, the government might also be surprised as well. What price then? All the assurances that might be given now. Thank you.
There are a great many arguments for and against Bills of Rights, some of which are put in the book. Some of them seem to me to be less than persuasive. The argument against a Bill of Rights that says that it will increase the earnings of lawyers seems to me to be an argument in favour. But so one does have to be careful how one characterises particular arguments. The one I'm concerned about is the danger of petrifying absolutes. There is a huge danger in the concept of absolute principles, mainly because there aren't any. To me, I don't know of any generalisation, including this one, which doesn't have exceptions. If you say there's a principle that one doesn't kill people, I say, what about self-defence? If you say there's a principle that one should never discriminate in employment on the basis of religion, I say, well, what if the Catholic Church wants to employ a priest? Can it insist that he be Catholic? If someone says you can't ever discriminate in employment on the basis of sex, what if I'm making a movie about Marilyn Monroe and want someone to play that role? I mean, the point is that all principles have exceptions, and Bills of Rights tend to petrify the principle at the expense of the exception. Now, if one had not a Bill of Rights or Charter of Rights, but a Code of Rights, if one had something with hundreds of sections, with exceptions, sub-exceptions, qualifications, and so on, that read like the Income Tax Assessment Act, I might well be able to bring myself to support that. But none of the Bills of Rights people want that. That's not what they're about. They're not about working out what the rights should be and fixing it. What they're about is laying down broad absolutes. And that, I suggest to you, is something that simply can't be done. It's interesting when one looks at the attempts to have Bills of Rights in the past. England had a so-called Bill of Rights in 1688, And let me just read you some of the sections from it. I won't read all of them in view of the time, but there's some lovely ones. There's a very detailed one about how the monarch can't be a Catholic or marry a Catholic. There's another one that says that subjects who are Protestants may have arms for their defence, but of course only Protestants. The whole thing was just an exercise in sectarian bigotry, but it's called a Bill of Rights. Magna Carta, a great document, you no doubt cry. Surely this iconoclast is not going to attack Magna Carta. Magna Carta said this: no one is to be imprisoned on the appeal of a woman for the death of anyone, save for the death of that woman's husband. Great principle, no doubt. If a man dies owing money to Jews, his wife may have her dower and pay nothing of the debt from it. Now, that's Magna Carta. I mean, these are so-called great bills of rights from the past, and all they demonstrate is the sexual and religious bigotries of the times. If our founding fathers had a Bill of Rights, we'd probably have enshrined white Australia and universal adult male suffrage. The enshrinement of principles can in fact be dangerous. Let me give you one final example before I sit down. In the United States, under their Bill of Rights, they have come to a doctrine called the poison fruit of the poison tree, which says that if the police obtain evidence in violation of one of your rights, that evidence cannot be used against you in any circumstances. The Australian rule, which we've developed judicially, comes from a case called Bunning and Cross, and says that if the police obtain evidence in violation of rights or illegally, then the court must judge the severity of the infringement of your rights against the importance of the evidence in the case and the matter charged and so on. We take a sensible approach, they take an absolute approach. Ironically, our approach gives the judges more power than the American approach. But let me give you an example of this. Suppose a serial killer is being pursued and he throws the gun into a garbage bin. And the police, without a warrant, come and search that garbage bin and find the gun with his fingerprints. In America, searching that garbage bin without a warrant would mean that his rights have been violated and the gun is inadmissible evidence. Although the violation of your rights in searching a garbage bin without a warrant is about as trivial as you can get. Now, it means you have no sense of proportion, a Bill of Rights. It means everything is absolute and rigid. Whatever injustice flows from it. And it seems to me that if we end up with a Bill of Rights, we're going to get lots and lots of injustice.
We in the Australian Christian Lobby are very pleased to see the publication of this book and really do congratulate Julian and the Menzies Research Centre on it. Nobody is more concerned about human rights than the Church, and particularly the Australian Christian Lobby, which I represent today, and we are constantly into parliaments on issues of violations of human rights, both domestic and overseas. And as Christians, we come from a very definite or definitive philosophical understanding of human rights, that they can be neither given or taken away by men or governments, but they are unalienable rights due to every human being because of their equality before God. They're being created in the image of God. Now, once we attribute governments with the power to give rights, then we implicitly give them the power to take them away. So with both a philosophical and practical interest in human rights, even a passion for them, the Australian Christian Lobby was keen to participate originally in this current human rights consultation, which is supposed to be looking at the best way to protect and promote human rights in Australia. But what's evident is, like so many well-intended processes, that this one has actually been taken over by those who have an agenda very specific for a specific charter or Bill of Rights, an ideology for it. It's meant that the conversation around this very important matter has been limited to the issue of a charter or Bill of Rights instead of the broader discussion of how best to protect human rights. It's a sad fact that nonetheless demands this book as part of the debate, so this ambit claim can be neutralised and the broader debate rejoined. Now, I'll just very quickly say that there are two specific things that we are concerned about in this issue of rights at the moment. One is we've seen, as people say to us, don't be worried about this, the churches have nothing to fear. We've seen with the only recently introduced Charter of Human Rights and Responsibilities in Victoria that an almost immediate consequence was to have a review of the exemptions and exceptions for religious bodies, including churches, religious schools, to their exemptions and exceptions from anti-discrimination legislation. Now, these exemptions and exceptions are essential for these organisations to work out their purposes and allow them, for instance, to actually employ people of faith into their organisations, and I might say guaranteed under Article 18 of the ICCPR. Secondly, and being as brief as I can, we believe that a Charter of Rights is essentially a selfish mechanism, because what it's aiming to do is to propel individual rights above rights held in community. And if that's what we're about as a community, then I think it's getting pretty sad. And we certainly, as a Christian lobby, want to see community rights protected as we nonetheless safeguard individual rights but don't pass a law that places them in some superposition and allows community rights held in community to be subjugated. So that's a very quick endorsement from the Australian Christian Lobby on this book, and I congratulate Julian and the Research Centre.
When should freedom of speech be curtailed to protect public order and morality? Where should the balance be struck between civil liberties and the right to security from terrorism? Now, many legal professionals, some of them on the bench, believe that the Australian people cannot be trusted to get these questions right. They know better, and they know better. Of course, pontificating about human rights is much more exciting than the tedious business of applying the laws of the Parliament. As P.J. O'Rourke said, everybody wants to save the world. No one wants to help mum do the dishes. But what is it that human rights lawyers want? Well, activist lawyers want to introduce a Bill of Rights so that when the people get it wrong on key moral issues, such as border protection and criminal sentencing and terrorism, we can be corrected by human rights experts like Marcus Einfeld. To allow an unelected and unsackable judiciary to second-guess the Parliament of Australia on key policy issues is to undermine the key principle of our democracy and the sovereignty of the Australian people. As Robert Kaplan has observed, globalised elites in the law, media and academia now have more in common with each other than they do with the citizens of their own nations. Their values are not our values. To paraphrase W.F. Buckley, I would rather entrust the Government of Australia to the first 400 names in the Sydney telephone directory than to the nation's lawyers. The legal profession must be reminded that its role is to uphold the law, not to rewrite the law. We must reject the Lawyers' Bill of Rights, and I commend the Menzies Research Centre for commissioning this important step to advance that cause for the good of Australian democracy. Thank you.
Thank you. I'm very mindful of the time, so I'll get directly to the point. First, I'd like to thank Julian for putting this together, but my contribution is made from the perspective of a Victorian lawyer. Now, we have had a Bill of Rights in Victoria for over 2 years now, so my contribution is in a sense a warning from the future that this book is trying to avoid. And what's become clear in the first few years of the Victorian Bill of Rights is that it's been the cause of massive uncertainty. A Bill of Rights of the kind that we have in Victoria requires courts to interpret laws to make them compatible with rights, but no one can say with any certainty what a compatible interpretation is. In Victoria, the meaning of a law must yield to a judge's honest attempt to make that law compatible with individual rights. Now, this is an inescapably subjective process. Now, under the proposed form of an Australian Charter, any law that could be said to affect a human right will be subject to the ambiguity of a compatible interpretation. Now, this has serious implications for public policy. If a politician proposed a law for, say, a new carbon trading regime, but couldn't say how that law would work, he would be ridiculed. Yet a charter is being proposed for Australia, and no one can say with any certainty how it would affect every law on the books. There is no certainty as to how a charter would affect, for example, anti-terrorism laws, immigration laws, corporate regulation, environmental regulation, criminal law, bail, crimes confiscation legislation, and organised crime legislation. Now, from a public policy perspective, this is madness. Now, I can't speak of the opinions of each of the contributors to this book, but I can say that each has put their arguments in the spirit of protecting individual rights and ensuring that Australia remains a fair and democratic society. And I hope that they're considered and enjoyed in that spirit. And I thank the Menzies Research Centre for the opportunity to share those views with the Australian people.
As a young Australian, I've been privileged to grow up in a society that has protected my human rights. I've lived alongside people of different values regarding work, life, family and faith. And somehow we've managed to coexist, going about our lives, working out our own values. But perhaps I should be ashamed because, you see, unlike the USSR, Zimbabwe and North Korea, I've also grown up in a society without a Bill of Rights. Perhaps my human rights have been hanging by a thread, and it's only by sheer luck that they've managed to exist so far without being trampled on. And so, because of this, people have proposed perhaps we need a Bill of Rights. Perhaps we need a Bill of Rights to protect our human rights. But I personally have a lot of concerns about this. The principal concern I have is that rights are really values, in my opinion. And these values often conflict with other values. The expressions of rights can get in the way of the expressions of other rights. In fact, even at the National Human Rights Consultation Committee process, the first question is, which rights should we protect in a Bill of Rights? Which? It does not assume that we will protect all rights, because it can't. They necessarily conflict with one another in some cases. Either that, or there are just general exceptions to them, and it's difficult to foresee them. I think one of the most difficult areas in which to work out rights is in the area of ethics. As a medical student, I'm particularly concerned with bioethics, and I see that on the cusp of the 21st century, we have so much that has developed in science and technology, and I believe our ethical discourse has not developed as quickly as our scientific advances. There will be so many opportunities to have great disagreements on big issues. In fact, there are some issues that have been around for a while, and still we can't seem to resolve them. One of the biggest of these is in the issue of abortion. And recently in Victoria, the decriminalisation of abortion in Victoria has a clause in it which I think is difficult even for people who have no ethical issue with abortion whatsoever. It's a clause that imposes on the freedom of conscience of Victorian healthcare workers and makes it compulsory for doctors who are conscientiously opposed to abortion to refer women on to other doctors who are not. This is seen to be forcing a doctor to be part of the process that enables a woman to procure an abortion. Now, personally, I won't try to justify my position here, but I personally am pro-life, and I do not want to be part of any process that enables a woman to procure a non-life-saving abortion. Now, Victoria actually has a Charter of Human Rights and Responsibilities, which is supposed to protect freedom of conscience and freedom of religion. That actually did nothing to stop this law passing. So you would think that perhaps I would be really disheartened by this law and have lost faith in Parliament. But actually, although I'm saddened by the Victorian Parliament's decision in passing that law, I would still rather trust in a sovereign Parliament where I can be actively involved in the democratic process in trying to remove this clause than in a Charter of Rights. When rights are addressed by specific legislation, it enables people to get involved in the process. Communally and individually, we can protest, we can send in submissions, we can lobby politicians. And if we don't believe that the legislation addresses our issues adequately, we can vote accordingly at the next election or try again. This freedom does not exist with the Bill of Rights. If the bill is passed, it is very difficult to remove. If there is significant disagreement over the application of one of the rights at the expense of another, the debate will not go to democratically elected parliamentarians, but it will go to undemocratically appointed judges. I believe in the processes Australia already has to protect human rights, even if they don't always work out the way I like. And I believe our best hope in strengthening human rights is by strengthening the processes we already have to protect them. If a Bill of Rights is introduced today, it's my generation that will flip the bill. We will be the ones who are stuck with it and its implications. And it's for this reason that I sincerely hope that we are not left with a Bill of Rights.
Just to wrap up proceedings, I'd like to thank everyone for coming. I'm sure you like to join me in thanking the editors and the authors for their contributions. The two remaining matters. The authors who haven't signed the books have to go and talk to Julian. And those of you who haven't bought the books have to walk past the bookstore, which is just out there on the right. I hope that's clear. Thank you very much for coming, everyone.